children.
Yes, Mr. Tomey, we've read the skeleton arguments. We've read both of the judge's judgments, both his first one and the second one. We have read his short reasons for deciding to reopen. And just to remind you that nothing should be said that would identify the children.
Lord, I'm very grateful. Shall I just introduce the counsel?
Yes.
Together with my learned friend Mr. O'Brien, I appear for the local authority in this matter. My learned friends Mr. Bagchi, King's Counsel, and Ms. Turner appear for the first respondent, the mother. My learned friend Mr. Garrido, King's Counsel, and Ms. Collinson for the second respondent of the appeal, father. And my learned friend Mr. Watson for the children's guardian.
Yes.
Though it's right to say that, of course, Mr. Forbes prepared the skeleton argument to which he will be speaking, which is in Relevance Bundles. There are, I hope, 3 bundles before the court, although they may be split across more than one branch file, I suspect.
Yes, we've got a core bundle in 2 files, a supplementary in 2 files, and an authorities.
I'm very grateful. And the additional document that I hope my Lord accommodated is a transcript of the mother's evidence by way of cross-examination.
Yes.
I'm very grateful. And my Lord's will, my Lady, will have seen that permission was granted on the 17th of August by my Lady Justice King. The appeal is brought in relation to all of the grounds that were permitted by the grant of permission. By way of introduction, it's right to say that in the first few weeks of child B's life, he sustained fractures to his skull whilst in his parents' care. And in the aggregate total of 6 months, that is the first 5 weeks or so, coupled with the period of his return with his sibling in the middle of 2021, so a total period of about 6 months, he has sustained 3 significant injuries to his head. My Lord, my Lady, he was removed with his sibling from the care of his parents, returning in March 2021 as a result of the, as it were, acquittal of his parents of any culpability in respect of the 2020 skull fractures. On the local authorities, the appellant's case, upon his return, really within days of his return, he began to sustain extensive and frequent abusive injuries, which appeared by way of bruising, culminating in the August of 2021 with his admission to hospital with significant swelling and bruising, some of which was unexplained. Second set of care proceedings were commenced, and it was the local authorities case that a redetermination was required in respect of the 2020 skull fractures. My Lord's already said that the court has had the advantage of reading the reasons, but it's recorded on the face of the order of the 12th of April in the supplementary bundle. I didn't take my Lord's.
Page which?
Page A340 in the supplementary bundle, paragraph 5, which reads that the court shall redetermine, as part of the fact-finding hearing listed below, the issue of whether the parents, or either of them, caused the fractures sustained by B on or before the 7th of February 2020, namely 2 fractures of the parietal bone, a separated transverse fracture extending from the right lamboid suture towards the coronal suture, and a second fracture running perpendicular to the transverse fracture. And the noted judgment is at A344, where the learned judge found there was a solid ground, or there were solid grounds. In particular, it's perhaps worth noting that he identified that the relevant background to his finding in 2021 concerning 2020 injuries was that there were no other concerns about the parents' ability to provide safe care and no evidence of unexplained injuries to be. The head injury was an isolated injury. Those were the express words used in reopening. Now, the appellant's primary submission is that whether by oversight or however, the learned judge lost sight of his clear and, we would say, convincing reasons for reopening the inquiry into the 2020 injuries. So necessarily, and I helpfully, one might start with that injury in 2020. And of course, having directed a rehearing, there was, as it turned out, a significant consensus as to the case management of that aspect of the case. And so I think one can take one's lead from that, or on that, from the local authority schedule in the core bundle at C1. It's largely the first paragraph in that schedule.
B which?
So the core bundle C1.
C, I'm sorry, I thought you said B. Yeah.
So paragraph 1 sets out the matters, I think it's right to say, all of which were agreed. That is, the injuries that had been sustained, how they were consistent with a forceful contact with an unyielding object or surface, the level of force, the likely reaction of the child, the likely reaction of a witness, the likely response of someone not witnessing, matters that could be excluded, and so on. And none of that was controversial. And the Lord has indicated that the court already seized of the detail of the original judgment.
Yes.
But it might be helpful simply to just draw from that original judgment some perhaps important points which should have been particularly pressing at the point of the rehearing.
Before we leave the schedule, it's a slight peculiarity, perhaps, but although it's clearly implicit in it that the local authority is saying to the parents, you caused these injuries.
Yes.
I don't think it's said in terms of.
No, that's right. That is.
I mean, I say it's implicit because the parents' answer is that it was caused in an accident.
Yes.
But insofar as it's said against you, that whoever drafted this didn't actually come out and say you did it. Is that a fair point?
It's not a point that caused any party injustice, primarily because the court determined it shall further.
Right, so everybody knew what they were talking
Everyone knew what they were talking about.
All right.
Yes. And indeed, as my Lord has indicated, the response makes that, I suggest.
Yes, but I mean, properly pleaded,
It should
there would have been another paragraph in addition to all the ones that are not controversial, including one which was very controversial.
Yes.
But that just simply didn't get put down.
Precisely so, my Lord.
Right.
That was an oversight, but in my submission caused no party any injustice at all. The judgment then is in the supplementary bundle at A331. And the analysis is to be found at A337, and in particular paragraph 31. And so it's clear that this was not a witnessed event. At Roman numeral 3, on the final page, 338, the experts do not rule out the baby bouncer scenario. It may be unlikely, but it is not impossible. The judgment records earlier, paragraph 27 on the previous page, how the child was not distressed and that the cry appeared to the mother to be a cry for milk and not a response to any particular distress. How nothing was heard of alleged incident, and how on returning from the adjacent room, the child not only was not distressed, but there was no change to his position. The child was unmarked. This is a child who is said to easily mark. The incident coincided with the mother's trip to the kitchen. And the concluding view at 31 Roman numeral 1 is that it simply was not credible that a devoted mother would have caused this injury, and that it would have been entirely out of character. The judge, then turning to the father, said that he was impressed by the absence of other injuries. In particular, he noted the absence of rib fractures or evidence of shaking. He said these are the sorts of injuries that one would be more likely to see if a parent had lost his temper with a child after, for example, trying to settle or feed the child, or because the child would not stop crying. So it's implicit there that the judge was satisfied that there was no such loss of temper. And of course, just pausing there, the local authority appellant would say that it's highly pertinent upon the retrial of this issue that the court should have found that in fact, on a subsequent occasion, not long after the child was returned to the father's care, he did indeed lose his temper and as a consequence assaulted the child, causing significant bruising and swelling.
Yes, because the judge says that he had to find the father had, out of character, hit him.
Yes. And clearly, the finding in relation to July indicates it was not out of character. Clearly, the incident in July indicated that the father was prone to lose his temper. And I'll come on to a little more detail, if I may, in due course. But the court was also, I suggest, upon the rehearing, required to engage with the arguments that had been made on the local authorities case and the guardian's case in the conclusion of the second care proceedings, but about the 2020 incident. So one can find those. Firstly, the local authority at A, in the supplementary bundle, A 871 to 2.
A, which?
A for Apple 871.
So that's in the supplementary volume 2. Yes.
Grateful. My Lord, I refer in particular to paragraphs 40 at 871 to 43. So the local authority drew the court's attention to the mother's description of the other child who might have assaulted the younger child as being gentle and not jealous. How she had told the police that the morning had passed without incident and she was only in the kitchen for a couple of minutes and everything was as it was before. The mother in cross-examination described going to the kitchen, sought some milk and toast. She gave the child a bottle and took him out to the park and recalled the child being upset. And no evidence that the cradle was disturbed in any way. The local authority submitted it significant because she said to the court that when she was in the kitchen she could hear the other child walking about, playing with his toys. So it would be reasonable to expect her to hear him jump off the sofa and land on his brother and the bouncy cradle. And they point to the difference in the cries. And the local authority went on to say that in answer to questions on behalf of the child, she indicated to the mother there was nothing to make her think that something serious had happened. And those were submissions with which, on our appeals.
Well, the way it's put is again a little bit delicate. Paragraph 38 of that document.
Yes.
The local authority invited the court to conclude that on the information now available, it's more likely than not that the injuries were caused by some other mechanism other than the bouncer.
Yes.
But again, it's all rather oblique.
I think the opening note of the local authority, I'll find the reference, perhaps makes it a little clearer. And then in relation to the Guardian's submissions on the same issue, they're further on in the bundle, it's A958. And if one casts one's eye down the subparagraphs of paragraph 29 of that document, many of similar points are made to those of the local authority. And then on the next page, there's a reference to the expert evidence of the paediatrician, little f. In particular, the presentation not being consistent with the child having suffered skull fractures, the reasons set out there.
But again, if you go to paragraph 30, I appreciate this is just the Guardian, it's not the local authority who is bringing the proceedings, stresses laid upon the fact that it wasn't being suggested the mother was being dishonest about this. I mean, in fairness to the judge, it doesn't seem until you show us something that, at least at this point in the pleadings, it was being stated that the only conclusion he could come to on the balance of probabilities would be that this was an inflicted injury. What seems to be happening is an interrogation of his prior conclusion, which was to accept that it had been a baby bouncer event. Is that right?
Well, I think it was entirely clear to all the parties, by virtue of the fact that the local authority had pleaded the case, albeit not as accurately as it might have done, but it prompted the responses of the parents, that the previous findings had identified, in the way that it's set out in that first paragraph, that but for some innocent explanation along the lines that was found previously, there would have to be perpetration by an adult. That was the tone and the tenor and indeed the conclusion, I think, of Dr. Hartledge, who's expressly referred to in this part of the Guardian submissions.
Yes.
But if it was caused, if it was an injury perpetrated by an adult and was not caused by the elder child jumping on the baby bouncer, would it not follow that the mother was being dishonest in proffering that as the explanation?
Not necessarily.
She said she was in the kitchen, she came out and found the younger child in the baby bouncer.
Yes. Nothing that she said, in fact, was controversial. Everything she said pointed away from the judge's finding. In fact, everything she said was relied upon to direct the court on the rehearing away from that initial finding. So there's no issue. That's probably why the Guardian's representative said what he did.
I see.
So it's accepted there was no unusual cry. It's accepted both children appeared to be fine. It's accepted the baby bouncer hadn't moved.
But I mean, all of this is building on sand from your perspective, because the window during which these fractures were caused was a period of several days before the admission to hospital, was it not?
Yes.
It didn't have to be tied
No.
to any described event.
No.
And what I'm trying to understand is whether, instead of building on evidence given by, in this case, the mother, the local authority had put the case, well, you can't rely on anything that's been said in the light of what we now know about what took place in July 2021. Could have happened any time, in any way.
I think that the local authority was clear that it did not accept this as an explanation for the injury.
Yes, but my Lord's point is that if it doesn't accept that as an explanation, then given that the mother has been found to have covered up in respect of another injury, what possible basis is there for saying, well, she says this or she says that about this injury? Why is she more reliable about that?
She indeed may not know what caused the injury, and so she may be telling the truth about that. But there were two parents, two carers, and it is possible, as the Lord knows, for one parent to be abusive and the other parent not to know. And so the fact that she said, all I can do is think of this incident, all I can do is think that this might have happened. Of course, that had to be considered, but it's right to say the background to this is that all sorts of potential explanations were considered in the original hearing. The only one that held any water at all was this one in relation to the potential actions of another child. But it wasn't witnessed, and the local authority's position is didn't know what happened. They did know the child had attended hospital with injuries that must have been inflicted by an adult, unless the court was persuaded of some freak accident. But there were no grounds upon which no evidence upon which the court could reasonably base that finding in the light of all the evidence now before it. In any event, the local authority submits that the land judge was bound to engage with each of these points, or at least the best of them. In the paragraph where the judge deals with the 2020 injuries, he does what he does, however, is he considers that injury alongside the other injuries. So the new evidence before the court required the judge to determine the serious injury in relation to the child's head and face, the bruising for the left side in mid-July 2021, the extensive scalp swelling and hematoma and the bruising to the left pinna of the same child on or about the 16th of August 2021, and the frequent and apparently excessive bruising since his return to his parents' care following the conclusion of the proceedings. So those are the three other new issues that now felt to be determined alongside the old issue. The outcome is found in relation to the judge's inquiry at the end of his judgment, where he summarises his findings. At A31 in the core bundle, he sets out those matters which he found. Importantly, in relation to the 2020 injury, at C, he found that in July, B suffered significant bruising and swelling in the way described, and found that they were caused by a blow or a slap with an open hand administered by the father after he lost his temper. And again, importantly at D, that the mother was aware of what had happened. She cancelled a visit by the health visitor, refused to allow even a doorstep visit, so the health visitor would not see the injuries to B. The reason she gave for the cancellation was false, and to that extent she'd failed to protect the child. So it follows on from that, although not necessarily expressly said, that it follows that the mother's account to the court, on the court's finding, had been false. The same for the father. The false accounts had been maintained for the duration of the care proceedings, and had been an account given to professionals investigating their children's welfare best interests for a period of about 18 months. And so, contrary to his finding in the previous proceedings, these parents were, in this regard, found to be unreliable witnesses, capable of lying, and capable of lying to cover up significant physical harm caused to one of their children. And he made certain other findings, at paragraph 77 of his judgment, at A26, in relation to the father's misuse of cannabis. Found that the mother downplayed the father's cannabis use. The father downplayed his cannabis use, indeed denied it altogether when the evidence showed that this was untrue. And he found, therefore, the father was using cannabis throughout the tested period of throughout the relevant period of April to August 2021. And none of those findings are challenged, but again, those findings in relation to cannabis and the lies about cannabis were relevant to the other allegations because they raised issues about the credibility of each parent, who are, after all, were the most important witnesses in the case as the primary carers of the two children. The local authority primarily relies on three well-settled legal principles in support of this appeal. And the first is that, of course, the court must take into account all the evidence and consider each piece of evidence in the context of all the other evidence. And evidence cannot be evaluated and assessed in separate compartments. And this is well established. Dame Elisabeth Butler-Sloss in 2004. In our bundle, we have a reference to the decision of, as he was, Mr. Justice Baker in re L&M. But the significance is that the court must exercise an overview of the totality of the evidence to come to the conclusion as to whether the case has been proved or not. That's the first fundamental and well-settled piece of law. The second is that well-settled guidance from this court in re-CTD, that the rehearing itself requires the issues to be determined afresh. We have that in tab 1. We've highlighted paragraph 8, A3. The issues are determined afresh on the basis of the whole of the evidence. The description of the event as a rehearing, rather than a review, is a deliberate one. Once a decision has been taken to reopen the case, the court approaches the task of fact-finding in the conventional way and reaches its own conclusions. It doesn't give presumptive weight to the earlier findings, as that would risk depriving the exercise of its fundamental purpose of doing justice or achieving the right outcome for the child. And then the third, final principle, we say, to the fore of this appeal, is that set out in B, adequacy of reasons, again, decision, my Lord Justice Peter Jackson, judgment. We've identified the passage, it's at tab 4, and we rely on paragraphs 59 to 60. But the phrase that springs from the paragraph, the engine that drives the decision, which needs most attention, is the evaluation and the explanation. And in this case, we will say that certainly in respect of the 2020 injuries, there was no such evaluation or explanation that came close to meeting the requirements of a judgment in such a serious case, or indeed in any case. The schedule that I've taken the court to already, in my submission, was a useful start because it identified the lack of a need for the recalling of expert evidence previously given, and it identified the narrow oral evidence that was required at the rehearing. But the narrow ambit of the oral evidence should not have detracted or distracted the judge from his primary task, which was a full rehearing. So although most of it was in writing and some little was oral evidence, it all stood to be reheard.
But is the position on a first instance judge deciding to reopen his own findings, is that the same process, as it were, as if this court set aside a finding and remitted for trial?
Yes.
In other words, you forget the first judgment, look at the evidence. You may not need to recall all the evidence, but the new judge hearing the case now makes up their own mind on the basis of all the evidence.
I'd say the simple answer is yes, because they're both rehearings. That label might, or rather I should say, the approach of a new judge upon a case being remitted for a rehearing might be quite different to that of a judge who's already heard the parties. So, for instance, it may be unnecessary for a judge who's already heard a particular witness to hear from them again. In this court, and indeed, my friend Mr. Bagchi will remember a case which went back for a third trial, so a second retrial. And Sir Mark Headley in that case took the view that because things had gone wrong in the previous two trials, whilst there could be a reference to previous inconsistent statements arising from the transcripts of evidence, the safest course of action
Would be to hear the
just hear it all again.
Yeah, well, I see that.
But it's a case management decision. So I think the simple answer is yes, it's a rehearing, and it depends on the trial judge whether it's the original or a new judge to case manage accordingly and fairly with an eye on the overriding objective. And in this case, we have no complaint, nor does I think any party have a complaint about how the attenuated approach to the 2020 allegation was initially addressed. And I would suggest, therefore, that although it wasn't pleaded directly in the way it should have been expressly against the parents, paragraph 1 of that schedule is a helpful tool which led to the case management proceeding, at least in that respect, fairly straightforwardly. So in relation to 2020, we say that there was, in fact, a compartmentalising of the 2020 incident, no regard to the wider canvas of all the evidence. There was, in fact, although an intended rehearing, it amounted to little more than a review. And there was no proper evaluation or explanation. So, in particular, in relation to 2020, having found that those injuries could or would have been caused by a parent losing their temper, and having found that that would have been out of character for these parents, then we say he was surely bound at the rehearing to weigh into the balance and to analyse his finding that it was not in fact out of character for the father to lose his temper with B, as he had found he had done so in July 2021. And furthermore, there was other evidence that illuminated the father's anger and impatience with B's whinging and clinginess. And one can see that recorded in the judgment at paragraph 76 at A25. Father is clearly angry or impatient with what he describes as B's whinging and clinginess. But the significance of these messages is clear, and particularly in relation to the 2020 injury, should have been weighed in the balance and should have been considered as part of the wider evidence. So now, when I say now, I mean now that the judge was sitting rehearing the case, as opposed to then, when he originally heard it, it was clear the mother was prepared to lie to professionals and the court about significant physical harm caused to B in order to protect the father and consequently not protect her child. Now, as opposed to then, he having decided that the father was essentially an honest witness, and one can see that expressly set out at the next paragraph in the judgment, paragraph 77, the top of A26, an essentially honest witness. It was clear that the father was prepared to lie to professionals and the court. Now, as opposed to then, the parents were shown to be capable of working together to prevent the truth from coming out, particularly by lying to a health visitor and putting off her visit. And the fact that the parents sought to play down the meaning of these messages, found at paragraph 76, A25, expressly by the judge, they played them down, and relied on by the local authority, paragraph 54 of its closing submissions, all fell to be considered, but were not thereafter considered by the judge. And more generally, the judge now knew that in the aggregate period of 6 months of these parents' care for their children, B had suffered 3 significant head injuries in their care. And now, as opposed to then, in 2021, he was aware that after a short period of B's return to his parents, he was sustaining, on the paediatrician's evidence, bruising of an extent and frequency which could not be explained by a constitutional issue, and which were, in many particulars, injuries to protected parts of the body, or parts of the body associated with child abuse, and particularly the soft parts of the cheeks, behind which there was no bone. So in summary, once it had been established that the parent had been significantly physically abusive to a child, the same child, as a result of a loss of temper, the inherent improbability that the court had originally considered of the same parent striking the same child on an earlier occasion became immediately far less improbable. And the improbable but possible unwitnessed theory of J falling onto B became immediately even more improbable. Nowhere in the judgment is there an analysis of any of those matters. Nowhere in the judgment does the judge ask himself, are any of these matters that I have found, or any of the evidence of the new matters, relevant to my findings in 2020? If this child was latterly assaulted, does that make an undisclosed assault now more likely? Is it relevant that the children's parents had lied about this? And so one turns to the analysis, which one finds in relation to the 2020 injury at paragraph, and only at paragraph 91.
Yeah.
And as I say, there is, within this paragraph, no express reference to any of those matters. It is right to say that the paragraph concludes as follows: having considered all the evidence that was before me in 2020, alongside all the evidence in these proceedings, I reach the same conclusions. Well, that is where the workings out, the engine room, needs to be exposed. This is where all the arguments and submissions, at least the best ones, required analysis and explanation as to why they did not carry the day. None of that appears. And so what one has is, at paragraph 91, the judge saying, what, as I submit, all parties knew, that the local authority invited him to conclude that the injury was attributable to either the mother or the father. So it is expressly set out in the judgment, and I say I must promise to try and find some greater detail to justify that, but it is expressly set out in the judgment that the court knew where it stood, the parties knew where they stood. This is what the local authority was seeking to prove. He then goes on to say that the local authority's case was, and here he doesn't, we submit, correctly identify the local authority's case, which was not that if you find one, then the other one must be proved. The local authority's case was far more nuanced than that. If you find one, then clearly those matters are relevant. Indeed, there was a further inquiry, was there not, about relevance, and one can see that 2 pages on at A33, which I'll come on to in a moment. But there's then this reference to the local authority, therefore, its case being fallaciously based. So it's a misstatement of the local authority case. But in any event, the court had to determine the allegation. He knew the allegation, he needed to determine it. So the judge then goes on to say in the 6th line, there is no new evidence about the state of the parents' relationship in 2020, which would lead me to consider what I said about the relationship then. But that immediately demonstrates, firstly, he was not considering all the disputed evidence as he had decided he must do by way of a rehearing. He was giving presumptive weight to one of his earlier findings. And he was wrong to state there was no new evidence about the state of the parents' relationship in 2020. There was significant new evidence he could have considered. The court had voluminous exchanges by way of text messages. If the court has recently read, or the court does read, the cross-examination, for instance, of the mother in the separate document by the guardian or on behalf of the guardian, she is cross-examined about the approach to her parenting and the criticisms of her parenting by the father in fairly explicit terms in text messages.
But what is the relevance of the state of the parents' relationship? You are saying, you have said, that what is significant, two of the significant things that emerged in the second hearing were, one, that the parents were working together to mislead or lie to professionals in the court.
Yeah.
That doesn't seem to shed any light on their relationship. And the other is that father lost his temper with the child and slapped him, causing a serious injury, which also doesn't seem to have much to do with parents' relationship.
Those are, of course, the primary matters. Yeah. The issue of the parents' relationship is the sort of matter that is considered in the wider canvas of evidence to identify whether there were perhaps tensions in the household that might have prompted inappropriate action. But just to take those two examples, having found that the father assaulted the child in the way he did, there are plenty of exchanges, some of which the mother is asked about, in relation to the different parenting styles. And there are a number of recordings of her saying that she was soft and he was strict. Firstly, the different parenting styles could give rise to dispute, but perhaps more importantly, they might indicate that strict was in fact abusive. The relationship, well, of course, if the first point that was made in relation to the cover-up, well, if the father, and on the finding of the court, the father did assault the child, and the mother was prevailed upon to cover up that, in other words, protect the father over the child, that of course does speak some volume about the relationship. And that's clearly pertinent to 2020. But it is more on the periphery of the matters the court has to consider. But they're all matters the court has to consider. But for our part, we don't really see why there's a concentration on that particular issue.
That was my question.
Yes. I'm sorry, I finally got there. And then there's the reference to some guidance from the High Court in respect of hindsight bias. We don't understand the relevance of that. We understand that hindsight bias use colloquial terms. I knew we were going to lose. They didn't play my favourite defender. I knew the team were going to lose. That's an example of judging something after the event with the benefit of the later knowledge. But that's not what this was about. The original event, no one was saying to the judge, you got it wrong at the time, and I know that because of all this information. What we're saying to the judge is, look at it again. We're not criticising the court for its first decision. There was no appeal. The court had to simply look at all the evidence. So hindsight bias didn't really come into it at all, and that was something of a red herring. And then finally, in relation to July, can I just turn on to A33 and the response to the question 2. The Guardian's question 2 was, why is the finding made of an inflicted injury by Mr. Smith towards B in July not relevant? The question is, why is it not relevant to the reconsideration of previous injury? So there's no suggestion that one's asking about propensity. The simple inquiry of the judge is, why is it not relevant? And the response is, well, I wasn't asked, I wasn't addressed on issues of propensity. I think, in fact, there were some issues on propensity in the documents. But be that as it may, he simply says, well, one event cannot amount to a propensity. But the question, correctly in my submission, asked the judge to consider whether it was relevant. And that was a simple question. And he might have decided it wasn't relevant. For our part, we can't see that it would be anything other than highly relevant. But having decided it was relevant, he then had to, had he done so, he then would have had to have given it some weight and analysed that information. But he doesn't do that at all. So we suggest that we submit that response to a simple inquiry, was this relevant, is in fact no. And that ties in with the paragraph 91. We also say that...
Just pausing
yes.
there. Propensity is a concept that is mainly found in criminal proceedings. And insofar as there's been some discussion of it in family proceedings, it's usually, I think, entirely on the basis of whether it is appropriate, whether it is admissible to take evidence from one set of circumstances and consider it in a different set of circumstances.
Yes.
I hadn't previously come across any suggestion that when one was considering what was going on within the same family over a period of time, that the issue was to be analysed in terms of propensity. It's a question of relevance.
Yes.
So, in your case, as I understand it, it's not appropriate to start thinking about propensity to do anything.
Well, that's right.
Where one is simply looking at something that's going on in the same context at different times. It's an ordinary exercise of consideration of fact and probability.
Well, precisely so. And when one reads a reference to propensity, of course, perhaps shadowing what Lord has already said, one goes to the authorities' relation to propensity as they apply to the family court. And after a little while, really one just comes back to that very simple statement of the law that I started with, to consider all the evidence.
In other words, it's not a question of propensity, it's a question of whether a question of cross-admissibility is evidence about one incident relevant when one's considering the other incident.
Yes, quite so. Is it relevant, and if so, how?
Yeah.
And what do I make of it in the balance with everything else?
So in other words, when the judge thought he was being asked to consider propensity, he'd actually misunderstood what he was being asked to consider.
Yes, and I said the question's quite clear.
Yeah.
The other primary criticism we make of the judgment is that this was in effect, a review and not a rehearing. That does tie, in fact, if the judge meant what he wrote at 94F on A31, with what appears in that subparagraph the last subparagraph of his findings. But there it is, clearly stated that it was caused accidentally for the reasons set out in the judgment delivered in the 2020 proceedings. That was not a finding open to the judge to make. He might have found it was caused accidentally, but he could only find it on the basis of all the evidence. And the 2020 judgment did not have all the evidence, because of course all the evidence came after, all the other evidence. Otherwise, in the substance of the judgment, paragraph 72 on A24, paragraph 72 suggests that he didn't feel it necessary to revisit what he described as his impression of both parents at that time. And not only was he wrong to assert that no party required him to revisit that impression, I mean, that simply could not stand as a reasonable inference to be drawn from the parties' approaches. The nature of the cross-examination, the local authority allegations, it was clear that the local authority and the guardian at least were inviting the court to revisit the impression that had been made on the court in 2021. Cross-examination about the text messages demonstrates that. And of course it was the very basis for the local authority seeking to reopen the 2020 issue, namely that the impression the court had gained of the parents was wrong. We say the passage gives presumptive weight to his 2021 findings. Say, July 21 findings required him, when starting again, to look at 2020 with the benefit of those findings. And the fact that he says he stood by his initial impression and hadn't been asked to revisit it meant he didn't reconsider his impression at all, in fact.
And perhaps he didn't understand what he was being asked to do.
Perhaps. But he should have done. Paragraph 77 is a reference to the father's honesty as found in 2020. I've already addressed the court in relation to the questions that flowed from the findings of the July incident in 2021. The fair reading of this passage we submit demonstrates that the judge stood by his finding in 2020 of the father. He certainly doesn't revisit it expressly, and he certainly doesn't say anything from which one can infer that he does anything other than stand by that finding. And that's perhaps especially significant, as I say, because of the July 21 incident, but also the findings in relation to cannabis. So two significant issues of dishonesty before the court, not revisited upon the impression of 2020.
Could I just ask this, where in his judgment in 2020 does he set out his impression of the parents? I find it difficult to see.
31. Yes, thank you. Finally. Yes, it's the concluding paragraph 31.
31.
Well, the penultimate paragraph, A337.
This is where he says that the mother was devoted and
Yes.
it would have been out of character for the father.
Yeah. I mean, I suppose it's fair to say it's something of a gloss on his own judgment.
So it's 31, Roman 1 and 2.
Yes.
That's the totality of his
Yes.
impression.
Paragraph 22.
He says they're in a committed
Committed
relationship.
relationship,
He's not. Well, I find it. He's not saying that they were honest witnesses or whatever it was, anything like that. Oh, he does say in 22 that father gave his evidence in a direct and straightforward way, so yes.
We have the advantage that this is not a second judge reviewing a different judge's judgment. So we know that that was his conclusion because he's told us that was.
Yeah.
And then finally, and this is in the transcript, alone it might have little weight, but perhaps against the background.
This is the mother's evidence.
Mother's, indeed, thank you. It's internal page 28. This is the cross-examination of the mother by or on behalf of the guardian, where the counsel asked the top of 28.
The first set of injuries, yeah.
Yes, I see. And then the mother's trying to say, well, it's not a theory. The judge found it, effectively. The judge says this: no, it was my finding, but I am being invited to reconsider it. No, he was reconsidering it. He had previously been invited to reconsider it. He had agreed to reconsider it. It may be that's just expressed in the exchange in court, but it does perhaps, if it is to be taken at face value, indicate that the judge had overlooked the decision he'd made, which was that this was indeed a re-hearing. The error in relation to the failure to consider all the evidence when considering one particular issue is repeated, we say, in relation to the bruising. I'll deal with the bruising in due course separately, if I may, but the decision-making in respect to bruising probably is confined to paragraphs 84 and 85 at A28. And within those paragraphs, which I would like to return to when I consider bruising in more detail, but within those paragraphs for now, it suffices to say there's no mention here of the matters relating to how the father lost his temper and inflicted serious injury to B in July, which of course was full square in the middle of the window that one is considering. And on the face of it, the father's conduct, each of the parents' misleading evidence and their attempts to cover up that injury in July were obviously relevant, but on the face of 84 and 85 appear to the judge to be irrelevant. They were not considered at all. And there's no mention more broadly of the evidence relating to August 21, the serious injury which precipitated the admission to hospital, or the old injury in 2020. And the same is true then in respect of the August, the final injury precipitating hospital admission. That I think is addressed at paragraphs 89 and 90, A29 and 30. No mention here of the finding in July or perhaps in particular issues about seeking of prompt medical attention. That was an issue for the August hearing, the August incident. Having found that in July, July 2021, the mother had failed to take the child promptly for medical attention. That clearly was something that would be relevant to what might have been said to be a delayed presentation in relation to the August injury. In other words, the second serious injury to the head in the short period of time where there was some delay in getting the child to a doctor. Why were those matters not even identified as being relevant?
In paragraph 89, the judge says that Dr. Cartledge accepted that the bruising was possible if B had struck the side of his head on a toy as he landed. Does the judge find that that is what happened?
I think he does. I think he does because I mean, the whole toy issue is an interesting issue because it wasn't witnessed. No witness said, whilst they saw the child fall, the child fell on a toy. It was a matter that came up in cross-examination where the possibility of a toy providing the hard opposing force jutting into the child's otherwise triangle of safety was considered, and certainly the doctor said, well, that could do it, yes, but there's no evidence of a toy.
Well, where does the judge find that that's what happened?
Well, I
if
think
he
it's
did.
At 94 E2, he makes the finding that it's caused by a fall onto the floor, and so it must follow that he considered that that's how it.
Yeah, maybe that's the inferential finding.
I think that's right. And then there's a response, question 3, A33. I said the blow could have caused the bruising. However, Dr. Partridge also said the bruise could have been caused if B had fallen on a toy.
But if consequence C occurs if A and B combine together, and you find A, but you don't find B, how do you conclude that C actually happened?
Well, you shouldn't. I mean, all I can imagine, I suppose, is that if one looks at it as a burden upon the local authority, the local authority has to prove this is an abusive injury. Just as with the 2020 incident, it is possible that there was some freak accident that accounts for it. In 2020, he was able to say, well, there were these unimpeachable parents, there's no reason to think that, why should I say it's abusive, even though all the evidence might point that way. It's still possible, if unlikely. But again, we have that now in August 2021 with the possibility. But what's significantly different between 2020 and 2021 is that the 2021 August incident was witnessed, but no one witnessed the toy being fallen on. So it's an even more abstruse point. It's almost as though the judge considered, accepted, yes, this evidence from the paediatrician demonstrates there has to have been a direct trauma to the pinna to cause this bleeding, extravasation of blood, the bruising. There has to have been a direct trauma. Is there any way that might not have been abusive? And the answer is yes. If there had been a bit of Lego or something the child had landed on with his ear. But there's no evidence of that. The court, of course, entitled to infer from surrounding evidence certain matters, but there was nothing from which he could infer reasonably that a piece of Lego or similar had been responsible. Of course, in relation to the pinna, he had absolute unanimity from the advising doctors. So the geneticist, Dr. Sager, expressly deals with the pinna in his report.
Yeah.
The evidence of Dr. Cartledge is important for obvious reasons, but can I just identify the matters that are particularly important in relation to the bruising? So I think this is in the set out in the. There are certain matters that set out in the judgment. There's one important, I think, passage that's not. So he deals with the doctor at A11 from paragraph 22.
Yes.
And fourth line down, asked about the significance of the location of the bruises seen in the photographs. He said the bruises on the soft parts of the cheek and on the ears were most concerning. Rarely are these caused accidentally. It's unusual for there to be accidental bruising on the soft part of the cheek below the cheekbone. Judge then goes on at 23. Body map, bruising behind the ear, this is the body map of August, of course, and to the pillar would be within the protective triangle formed by the top of the head, the chin and the shoulder. So he records that. He also records that the photographs cover a number of months. From those, the doctor concluded that B did bruise more easily, but that this bruising was different in extent to that noted before he was removed. So again, he's got that. What he did not expressly recite in his judgment, but again had in with absolute clarity from the doctor in the addendum report, which I think is right at the back of the core bundle. The addendum report of Dr. Cartledge, received in the light of the geneticist report from Dr. Sagar. So taking into account the PTS.
Yeah.
C464.
464.
Yeah, in other words, it's the last page, just the penultimate page of the core bundle. Sentence begins at the bottom. I think that at least some of the frequent and extensive bruising was most likely caused non-accidentally. It's in the light of the...
Yes.
So that is a clear conclusion of the expert. And of course he's entitled to depart from that expert evidence, but again with reasons, and good reasons. Having said that, it does record when dealing with Dr. Sagar's evidence at A10, paragraph 19, how Dr. Sagar, third line, would agree with Dr. Cartledge that at best this condition would explain only some of the bruises. So it's there in that way. And of course, Dr. Sagar had said that he would refer to Dr. Cartledge in relation to the location and incidence of bruising. And then finally, in relation to Dr. Cartledge, he doesn't make reference to the point made in oral evidence by Dr. Cartledge that, yes, whilst the child might latterly, his later bruising would be relevant, one would expect even more bruising once he's removed from his parents' care because he became even more mobile. So that would have been something to have weighed in the balance. So the expert evidence is clear. The extent and the frequency of the child's bruising and the position in which they occurred point towards perpetrated non-accidental injuries. Nowhere, we submit, does he tackle that expert evidence. What he does do is deal with some of these matters at paragraph 68 when he considers the evidence of the foster carer. A23. He refers to her evidence, and from the top of A23, 5 lines down, I'm unable to conclude from this evidence that B did not bruise any more easily than a child without HSD. Probably wasn't the question, didn't take the matter any further in my submission, it's a neutral finding. And then further on in the paragraph, finally, there's the evidence of Dr. Cartledge. Photographs taken after B was removed from the care of his parents showed a greater tendency to bruise, although not to the same extent as when he was with his parents. And then he says this, a difference that might readily be explained by the quality of the care given by foster carers and the grandparents. So, in relation to that, I suppose that might be so. One might have wanted to have asked the paediatrician about it, but that issue was not raised with the paediatrician. So we don't know what the paediatrician would have said about better care. Of course, none of that goes to answer the paediatrician's primary concern, which is more extensive and frequent, and the position. And simply saying that what he does in this paragraph doesn't address those points. And he goes on.
But in a sense, isn't the whole case about the quality of care?
Yes. Yes. Yes, it is. These are care proceedings. There was a wealth of evidence upon which the judge could and should have concluded that these were abusive, bruising injuries.
In relation to the last injury, your case is that effectively the judge was calling upon you to prove that the injuries were not caused by a fall on the floor involving some sort of object such as a toy, an object of a kind that the mother had not said had been involved in the incident.
Right.
Which she herself witnessed.
Exactly so. I would submit that in relation to the bruising, the judge nowhere deals with, leaving aside that the issue of frequency and the extent of bruising is one matter. Leaving that aside, where in the judgment does he really get to grips with the paediatrician's concern that there is extensive bruising on frequent occasions to the fleshy parts of the face?
You're moving to a different point. Yes.
I'm agreeing with my lord. Yes.
Well, I'm not saying anything for my own part. I'm just trying to understand what your submission is.
Yes.
Which is in the first case, it's to do with reconstructing an unwitnessed event. And on this occasion, it's to do with embellishing a witnessed event.
Yes. Well, insofar as the embellishment goes, as far as it does to acquit the carers of culpability, then it is recasting it in the same way as the first. Well, I know the court has the report of Dr. Cartledge. There are, I can take the court to, a number of the soft tissue injuries, but perhaps I can leave it in this way, unless I can assist the court further, that in relation to the soft tissue injuries, particularly to the cheeks, of which there are many, and to which the response of the parents is either, I don't know, or I don't know, but I suspect it's got something to do with him being more clumsy or being more prone to bruise. That didn't meet the issue that the paediatrician was making, and to which the geneticist deferred, which was that these were two areas which should not be injured in the course of ordinary lay.
Yes.
I think in the course of dealing with my submissions, I've probably said most of the matter I wish to about the August, which has been cast, as it were, as a discrete injury, but of course all part of the wider picture. May I just see if there's anything that Virginia wishes me to firstly, in relation to my Lord Justice Jackson's inquiry about the way the local authority put its case, the local authority opening note might assist at supplementary bundle 349, paragraph 349, my Lord.
Thank you.
Paragraph 17. The opening of the note from the father, or on behalf of the father, at 355, paragraph 7, addresses the allegation, particularly perhaps at the end of that paragraph.
Yes, I know. But we're in the same position, aren't we? That I mean, it's one thing to disbelieve the parents, but really, if a case this serious is being put, one really wants to come out and put it. I understand the point. By the time it got to the judgment, the judge well understood that you were suggesting the parents had caused this injury by a mechanism that you couldn't specify. But nevertheless, it's not, as I think you accepted before, terribly satisfactory to leave these sort of things unsaid.
Well, I agree, and can I say this, that I suspect it is perhaps the difference between a rehearing before the same judge and a rehearing before a different judge, where it's what is understood by the parties, or a fresh set of proceedings, what is understood by the parties to be the case isn't set out, but is understood by the parties. So it's less than satisfactory, but it did not give rise, in our submission, to an unfairness. And in relation to that, of course, the allegation made by the local authority and agreed was that the cause of the fractures in 2020 had to be by a mechanism which met certain criteria.
Yeah.
And then finally, in relation to the father, the judgment from 2021, I hope it's the supplementary bundle 336. So 336, little Roman numeral 8. 336.
Well, paragraph 20, Roman 1, the judge quite clearly says that one of the issues is whether the skull fractures were caused by the mother or the father.
And then, so it's in relation to the father and the text messages, how he had stopped taking the drug. There's no reference to any further instances of domestic abuse after April 2019. I accept, as submission on behalf of both parents, that the parents have moved on from that particular episode. So gave particular weight to that improvement in their relationship.
Yeah.
Then over the page, 337, paragraph 31, subparagraph 2. It would be wrong to conclude simply from the past history of domestic abuse that the father posed some risk of harming his child. Are there any other matters for which I can assist the court?
just ask what it is exactly that you're asking us to do. To allow the appeal, to remit the matter for rehearing.
Lord, yes.
And is that on the basis that all the findings made by the judge are deleted?
We cannot see that it would be fair or proper to do otherwise.
I imagined you would say that. You're not seeking to, as it were, bank findings arising from what you say is an unreliable process. Obviously be a matter for the parties on a rehearing, if there is one, as to what are the issues and whether anything is agreed or accepted or not.
Quite so.
But essentially, if there was to be a rehearing, it would have to start with a blank sheet.
Lord, I certainly agree. One matter that the court might or might not feel able to comment on, if there were to be the appeal allowed, and that is the judge's finding that the bruising did not amount to significant harm. Whilst this court wouldn't be making a finding, this court might give some guidance as to, if certain bruising is found, whether it could realistically be said that that did not amount to significant harm in the circumstances.
Well,
that's as far as I would go.
I hear what you say about that. That was what I wanted to ask. Thank you.
Thank you very much, Mr. Watson.
My Lord, thank you very much. On behalf of the Guardian, my Lord, we of course support the appeal.
Yes.
You've already indicated that you've got my skeleton argument. I have listened very carefully to the submissions that you have just heard, and I support them all in their entirety. My Lord, you have been taken already to certain aspects of the material that was of course filed on behalf of the Children's Guardian at different stages of this process. And indeed, you've already referred to one or two things I was going to take you to, and I don't intend to repeat that. I don't think that would assist in any way. My Lord, just one thing, if I can, in relation to the closing submissions on behalf of the children in the second set of proceedings. You've already been taken to this, but just to highlight that A956 of the supplemental bundle, that in my submission contains perhaps a helpful summary of the whole issue. You were taken, of course, to a particular aspect of it, but it sets out in summary form the medical evidence.
Yes.
It sets out how the issue arose, and then it analyses the problems that, on behalf of the children, it was said that there were with that particular hypothesis in relation to that particular incident that wasn't witnessed.
Yeah.
So, my Lord, I just wanted to make that clear that it, I think it extends beyond the reference that you were given. My Lord, I am very conscious that I don't want to repeat anything that's been said. In terms of the question that was just asked about the process, if you were to allow the appeal, I accept the analysis that's been put upon that. I accept that it wouldn't be fair to try and, as it was put, bank anything, and it would have to proceed afresh. So I accept that, Lord. Lord, can I assist any further?
Thank you very much. Yes, Mr. Batchy.
May it please you, my lords and my lady. We have prepared a skeleton argument which sets out some, I hope, fairly brief but focused submissions.
Yes.
Which very much place emphasis on the well-known authorities which arise in circumstances where any appellant seeks to disturb the findings of a trial judge in relation to an assessment of facts.
Yeah.
They're effectively summarised in three authorities, which are well known to this court. I don't think I need to take my lords and my lady to them. They are Piglowski, Reby in the Supreme Court, and the case which I think is pronounced Fahy, all of which are set out in the bundle of authorities, right? All of which emphasise the very high threshold which any appellant faces in disturbing the primary findings of fact made by a trial judge. We add to that by saying that this was a judge who had heard this evidence on 2 occasions, had more than ample opportunity to make an assessment of the credibility of the parents, and had indeed engaged in a process in both trials whereby those parents were tested exhaustively in their oral evidence, and the learned judge made an assessment of their credibility and set out in both judgments the product of that assessment. In those circumstances, we submit that where so much of the learned judge's reasoning focuses upon the account given by the parents, not only in relation to the incident in 2020, but the events in 2021, it is very difficult for this court to come to the conclusion that a different conclusion on the facts ought to have been reached.
I'm not sure that's the issue for us. We're not concerned with whether a different issue, a different conclusion ought to have been reached. We're concerned with the integrity of the process that was undertaken.
Yes.
And whether that was a valid exercise.
Yes. Well, let me first focus on the findings in relation to the 2020 head injuries and the rehearing arising in relation to that. The principal complaint is that the learned judge's reasoning, I think set out at paragraph 91 of the judgment, was, I think the first complaint effectively set out was that the learned judge applied the wrong test. We have sought to demonstrate, by reference to my Lord's decision in CTD, that the learned judge's expressions in paragraph 91 of hearing the evidence arising from the subsequent proceedings alongside the evidence arising from the proceedings which began in 2020 was indeed a correct application of the test. That is precisely the task which this court has set for tribunals engaged in a rehearing, to give no priority to earlier findings, to give no priority to earlier evidence, but to assess the fresh evidence alongside the evidence before the court previously. In directing himself in that way, it's our submission that it cannot be said that the learned judge fell into error. The real question which arises is in relation to the totality of paragraph 91, whether he sets out with sufficient clarity his reasoning. And that calls into question the extent to which it is necessary for him to go further than what he said in relation to his assessment of the parents' credibility. And in our submission, although, of course, any judge can, after the event, be criticised for not having given as full a reasons as any judge might be prepared to give in certain circumstances, we would submit there is sufficient analysis in paragraph 91 to enable the losing party, in this case the local authority, the Guardian, to know why it is indeed they have not succeeded. And it's essentially because after a process by which the parents were subject to extensive cross-examination and a re-examination of their personal history, their text messages, and the accounts that they have given in relation to how the injuries arose, the learned judge has broadly accepted the credibility of their accounts. And he's in a unique position to be able to do that. And that is the guiding and principal factor which drives the conclusion of his judgment. Moreover, we submit it's of significance that the learned judge simply did not accept the parent's account wholesale across the piece in relation to the subsequent injuries arising in 2021, and made findings in relation to the father's conduct on one occasion and in relation to the mother's covering up of that particular incident, which demonstrates to this court that the learned judge wasn't simply closing his mind to the possibility that the parents were not giving a full and accurate account of events, but applying the learning in Lucas, as tribunals of fact are mandated to do, he was perfectly entitled to come to the conclusion that the parents had not been frank about those matters, whilst accepting that they had been honest to him about other contentious matters, and that putting the whole picture together, he was not satisfied that the local authority had discharged the burden of proof which rests upon them in relation to the proof of the primary allegation. So those are the points that we have made on paper, and those are the points which we would seek to emphasise to you today. There's just one point of detail I want to raise with you, and that arises in relation to whether it is open to the learned judge to come to the conclusion that it was possible that there was a toy on the floor in relation to the August 2021 injury. And I think it arises in the evidence in the supplementary bundle, I think at page 653. This is part of the questioning of the mother.
This is right. This is mother's cross-examination.
By the father's counsel.
Yes.
And right at the bottom of the page, of 652, the passage begins, right at the bottom, at line 31. There was a query from Dr. Cartledge as to whether Brooklyn fell onto something or just the floor. Do you have any recollection of whether he landed on something or just the floor? You may not. The answer is, I can't be 100% sure, but there's toys always on the floor when the boys were playing, but I can't recall. I really don't know, sorry. I think that's probably the high point of the evidence in relation to the presence of toys on the floor, that she thought there were always things lying around, but she couldn't be sure. In our submission...
I think there might be a higher bit of ground than that. If you go back to the call bundle, there's a statement by the health visitor.
Yes.
At page C86 to 87, where there's a witnessed account of being falling on a toy.
On a previous occasion.
On a previous occasion.
Yes.
And there are also photographs.
Yes.
The circumstance in which they're taken doesn't really matter, but they show the ordinary sort of living room in which small children exist, in which there are toys around.
And we submit this is plainly something that the learned judge was entitled to bear in mind when considering the inherent probabilities across the piece. Very often, as my lord knows, in these cases, events are unwitnessed, and the court has to stand back and try and work out what could have happened.
Yes, but when you're thinking about what happened in August, you're also bound to think about what happened in July.
Yes.
And that's the case that you really are having to meet, because the August situation is not the July situation didn't just involve apparently a loss of temper, hiding of the child. It involved the putting forward of a false narrative to do with the child having fallen between the bed and the wall. And an agreement between the parents that they were going to conceal what was going on. So all of that was within I haven't counted, but it's only a few weeks, if not days, before this incident about the fall on the floor.
Yes. Well, the point I make is the learned judge did make those serious findings. So he did come to, he did it in those circumstances.
Yes, but if you had, let's suppose that there had been no injuries in July, and that any reference in the or at least let's suppose the judgment contained no reference to injuries in July, then if one was reading about the August event, one wouldn't know it had happened.
Yes. From the reasoning, you would not know that the learned judge had come to certain conclusions about the July incident and weighed them in the balance in arriving at his conclusions in the August incident. I accept that, but even though he didn't express it in that way, it is plain, in my submission, standing back, that having made very serious findings in relation to the July incident, he must have weighed that in the balance when making his ultimate determination of the inherent probabilities and whether or not the local authority discharged the burden of proof in relation to the August incident. And the mere fact that he doesn't express it in paragraph 91 expressly may of course be not optimal, but in our submission it's not fatal to the overall conduct of the hearing and his analysis of the evidence which resulted in the findings that he made. I think that's the way in which I'm constrained to put it on behalf of the mother, given the way in which paragraph 91 is framed.
Yes.
I just want to say something about propensity and the extent to which that seems to have featured in the learned judge's thinking. Not having been present at the trial myself, it's not clear to me the extent to which propensity featured in the oral argument before the court. What I have been able to establish is that there are some references to propensity in the submissions, I think, made on behalf of the mother, and that her written submissions at pages A892.
This is in the supplement.
In the supplementary bundle. And a little bit further on, a reference to the legal principles applicable in relation to the assessment of propensity at A904, mentioning the criminal case of Crown and Mitchell, approved in a subsequent children's case. I think I have to accept the force of the reasoning in relation to the role that propensity plays in the assessment of facts in care proceedings. It's very rare for any party, still less any court, to give evidential weight to any particular prior fact by virtue of the label propensity. In care proceedings, it's well known that all evidence is potentially relevant, and the extent to which weight is given to any evidence is a matter for the individual case. I think the effect of the exchange between counsel and the learned judge after the judgment, which I think we see at page 33 of the core bundle, seems that the learned judge was effectively interpreting the question as one which signalled an intent by the questioner to rely on the fact that findings had been made in relation to subsequent incidents to inform the outcome of previous incidents. in a way, it's a sort of reverse propensity, because the timing is the other way around. What one usually might say is that in relation to prior findings, that establishes a propensity which opens the door to make subsequent findings. Here what was being said is that at the point when the learned judge made his original decision, certain events hadn't yet happened. Once they had happened and findings had been made in relation to them, that entitled the court to look backwards and to say that those subsequently found facts achieved some sort of propensity to commit the earlier injury. But the use of the word propensity in that context is totally unhelpful. Yeah. And the test is relevance. One can see why it can be said that subsequent events might cast light on earlier conclusions because they may be relevant. Whether they fit the model of propensity is neither here nor there.
It's really, I think it arose in questioning with my lady earlier on, that it's really relevance to the probabilities, isn't it?
Yes.
Is the conventional way in which we approach these.
Indeed. And of course there are, bound in with that, are all the difficulties arising in relation to the assessment of inherent probabilities in circumstances where the medical evidence can only go so far and leaves open a whole range of medical possibilities. And the court then has to assess the extent to which the inherent probabilities shift the dial in one particular direction or another. And of course what we would say in this case is that bound in with the court's assessment of inherent probabilities, very significantly, was the court's assessment of the character of the parents. So first time round, the learned judge has effectively come to the conclusion that these are not the sort of parents that would do that.
But the second time round, he finds that one of them did.
Yes. And yet was able to maintain his central conclusion that in relation to the other events, sufficient distinctions could be drawn between what he found and what was alleged to justify the conclusion that they might have been the sort of parents to have, or the father to have perpetrated the injuries as he found them to be, but that did not create a sufficient evidential link to justify serious findings or findings in relation to the earlier event. And that is the reasoning which we submit is plain to see from his judgment. My lords, I don't think there's anything else I'd seek to add to what we have submitted by way of written contribution. I'll just turn my back if anything. Thank you very much.
Yes, Mr. Gary then.
Yes, my lords, my lady. We join with my learned friends, Mr. Bagchi and Ms. Turner, in opposing the appeal for the reasons we set out in the skeleton argument provided to the court. I'm sorry we didn't have time to file a replacement skeleton with the appropriate bundle references, but the preparation of the appeal has been done, understandably, in a short period of time. We too, very briefly, set out just some of the cases that we could have set out in respect of the warnings which this court gives to itself quite frequently in overturning the decisions of judges at first instance. Without knowing that my Lord Lewison was on the Constitution, we alighted upon the quotation from the Yoggurt case, which is often referred to. But of course, we could have referred to many other matters. And we set out in some detail, perhaps, understandably, given the position that we find ourselves in defending the judgment, in emphasising the considerable and demonstrable advantage that Judge Wicks had at first instance. There has, of course, been a considerable disadvantage to the children, to the family, in the amount of time that it has taken for these issues to be resolved at first instance in two separate trials.
Well, that's very unfortunate, but can't really affect the outcome of this appeal, can it?
I don't suggest that it does, my lord. But what I do suggest is that the number of hearings over a significant period of time has added to that demonstrable advantage that Judge Wicks has of having seen the parents not only in 2 trials separated by a year, but also at several hearings within each set of proceedings, and over several different hearings within the final hearings in both cases, where there were gaps between the hearing of some evidence and the hearing of other evidence.
Yeah.
So, whereas in some appeals, the court at first instance might have seen the parents for 3 or 4 days, here he's seen them day after day after day over a period of several years, both at interim hearings and at final hearings.
I think on the point my Lord raised, essentially the decision for us is an all or nothing
Yes.
decision. That there are some cases, for example, where even though an appeal is allowed, it might be said, well, there doesn't need to be a rehearing because, for example, the findings that have been made are sufficient.
Yes.
But nobody is arguing that point here. And so, although obviously we're mindful of the stresses that these proceedings have already brought,
Yes.
it's all or nothing.
Well, my lord, unfortunately so.
Yeah.
And that's why we don't emphasise the disadvantages to the children and the family by what has happened at first instance over the course of a number of years. I know my learned friends, on behalf of the mother, set out in a paragraph within their skeleton argument precisely that. We associate ourselves with that. No doubt the court would associate itself with that disadvantage. But absolutely, it plays no part in the court's decision if the judge has fallen so far below the requirements of a first instance judge that his decision has to be overturned. There will have to be a rehearing.
Yeah.
That will inevitably cause further delay. But unfortunately, that is the consequence. So we emphasise the considerable understanding, the opportunity that judges had to consider the positions of both the parents. And it is clear that running through both his judgments is that he is drawn to not a sympathy for the parents, but a belief that they are that they have behaved as well as they could have done in the circumstances, save when he was drawn in respect of the July 2021 incident to make a finding against the father, a serious finding of an individual incident with a particular mechanism, a slap to the face. Our instructions remain that father doesn't accept that position. I have to be plain about that. But nevertheless, there were particular features of that injury which led the court to come to that conclusion. Features that were different to the features of the other injuries that the child had suffered at different times, and enabled the judge, therefore, one might think unusually, to be able to distinguish between what happened in July 2021 and what happened in February 2020 or throughout the summer and most recently in August of 2021. And that, we say, was perhaps an intangible, both to this court and to those advocates who weren't present at first instance, but an intangible impression that the court received over the considerable period of time that he had to get to know both of these parents. Of course, we don't have to repeat what is said at paragraph 4 of our skeleton argument. no judgment has to be a counsel of perfection, obviously. The question is, did this, we say, fall so far below what was expected? And we say that on a careful analysis, taken as a whole, that it didn't fall so far below. We can't suggest that this was perfection, if perfection can ever be achieved in a judgment of this sort. But it was sufficient. It was sufficient to explain to the parties the way in which the judge had come to his outcome, and it was sufficient in terms of demonstrating his understanding of the principles that he was to apply. May we move on, therefore, to the specifics and essentially the first ground of appeal, which finds its reflection in 1A and 2 in the grounds, and that's regarding the skull fracture in February 2020. Did the judge undertake a necessary rehearing or review of the first findings in order to satisfy what this court has determined is necessary from the case of re-CTD? And here we emphasise the need for the judge to do something more than simply a appellate-style review of the first decision. At stage 2 of the requirements set out in CTD permit, we submit, a wide variety of types of rehearing. So it permits circumstances that have already been explored with my learned friend on behalf of the local authority. It permits a new judge coming in, hearing all the evidence afresh, both from the first proceedings and any subsequent proceedings, and essentially conducting matters all over again, including hearing the expert evidence. But stage 2 also permits, we say, what happened in this case, which may be described as a light touch rehearing, but as circumstances in which essentially no new evidence was heard about the circumstances in February 2020 and those injuries. The only new evidence that was heard was about what had happened over the summer of 2021. And the judge was therefore left to reflect on what it was, if anything, about what he heard of the injuries in 2021 that led to impact on his decision in 2020. And the reason why we emphasise the curious decision on behalf of the local authority to plead its case in the way that it did isn't to suggest that the father and his legal team were put at any sort of disadvantage by the failure to plead the causation of the injury properly. That's not why we raise the point at all. We raise the point to justify what the judge says in his judgment about the way the local authority put its case and what he understood of the way in which the local authority put its case. So when at paragraph 91, the judge identifies essentially what the local authority's case is about the 2020 injury, which is that what has become known of the family's circumstances in 2021 is sufficient to undermine the original finding. That is, we would say, far from the fallacy that is suggested on behalf of the appellants, that is precisely the way in which the local authority and the guardian put their case in respect of the 2020 injury. Not by introducing any new evidence, but by saying in terms to the judge, you can't possibly maintain the accidental causation of the skull fracture, because look what happened when the child went home. All these injuries were caused. Incidentally, they didn't specify how many injuries. They refer to 30 photographs and suggest that there are a number of injuries, some of which may be accidental, some of which may not be accidental. But they say that all muddies the water in respect of the causation of the 2020 incident. And the judge responds by saying, well, no, it doesn't. The circumstances of this family in February 2020, 18 months previously, were very different. Even if the judge finds, as he does, a tension in the parenting in the summer of 2021 between mother and father, no evidence is provided to him that that same tension was present in February 2020. Now, the tension in the summer of 2021 was essentially being put as one of the red flags that would indicate that here is a household in which non-accidental injury may occur. And the reason why was the judge thought it was important to determine whether or not that same tension existed in February 2020 was because that may be a red flag as to the non-accidental causation of the skull fracture. But if the circumstances remained very different, there might well be no reason to review, to revisit, to undermine the original findings on the basis of the new evidence.
One slightly unusual feature of this case is that at the conclusion of both of the trials, the judge made findings that went beyond what he needed to do, which was to decide whether the local authority had proved its case.
Yes.
And made positive findings of accident.
Yes.
So when you're talking about what the judge was revisiting in 2020, he was revisiting a finding that this had been an accidental skull fracture.
Yes.
Not simply that the case had failed for want of proof. And that finding that it was an accidental skull fracture depended to at least some extent upon accepting the credibility of the parents. And so the judge wasn't even prepared, in a sense, to say, well, insofar as I relied upon the parents' accounts of anything, I don't feel safe to do that any longer. But making all allowance for that, I still don't find that the local authority case gets over the line.
Yes.
Instead, he left a finding which was dependent upon the parents' credibility in place.
Well, he continued to believe what the parents had told him about either what they had observed in respect of the 2020 fracture and the other bruises in 2021. He continued to believe them, either in that respect or in the respect that they simply didn't know how these bruises were caused. Clearly, despite the fact that he had to find that they had lied to him in respect of the...
It isn't, as I pointed out before, just a question of lying or not telling the truth about it.
Yes.
There's an established instance in the judge's mind of them having created a false account.
Yes.
With the bed.
Yes. And that may seem, looking on outside of the trial process, even to those as advocates, that may seem an odd position to take.
There's also the position that he found in the first trial that it was out of character, would be out of character for the father to injure the child.
Yes.
And yet in the second trial he found that that's exactly what the father did.
Well, my lord, he found that's what the father did, but but it was still out of character for him, the judge determined, because the judge believed, or at least accepted, what the parents' case was, which they had no responsibility for the other injuries. And so that finding must have been on the basis that this was a momentary lapse on the part of the father, that this was out of character. This individual incident.
Doesn't say that, does he?
Well, not in terms, my lord, no. We have to accept that. But how else can one rationalise?
Well, that's the question. Can one?
Well,
you start from the premise that you can,
yes.
and therefore you seek an explanation, but that's not the question that we're answering, is it?
But my lord, if that's a reasonable explanation, if the judge is able to come to the conclusion that one incident occurred, that it doesn't have to automatically infect the decisions. As I think we put in our skeleton argument, perhaps too glibly, it's entirely possible for a child who's non-accidentally injured also to suffer accidental injuries.
Yes, of course.
Entirely possible.
Yeah.
And in this case, although the 20 or 30 odd bruises that were pleaded as a result of the photographs, it was accepted by the time the local authority came to its closing submission that that didn't represent 20 or 30 different moments of injury, and also that some of those injuries were likely to be accidental injuries because Dr. Cartledge had accepted that some of those injuries were likely to be accidental. So we have a case already where it is common ground that some of the bruises that the child suffered were accidental. The question is whether all the others, barring July, are also accidental, or whether, because of the July finding, that the other serious incidents, notably the fracture in February 2020 and the head injury in August 2021, must be, or are more likely to be, non-accidental, solely as a result of the findings that were made in order to establish the non-accidental nature of the July injury. And we say that the judge didn't automatically have to come to that conclusion. Indeed, he factored in his overall impression of the parents so as to justify not coming in to that conclusion. So, my lord, we emphasise the equivocal nature in which the local authority put its case on the causation of the 2020 skull fractures. My lords, my lady, have already been taken to the final schedule that was filed by the local authority, the first document in C section of the core bundle. When the local authority came to its opening note, although my learned friend on behalf of the local authority sought to suggest that the opening note provided more clarity as to the local authority's position, in our submission it didn't do so by much, if at all. If my lords, my lady, go to the supplementary bundle at A349, PDF 351, at paragraph 15, the local authority leave open, it would appear in their opening note, the possibility for the court to make two different contradictory findings, and simply says to the court, well, the decision for the court to make is whether the injuries in 2020 and 2021 were inflicted by the parents or one of them, or whether they were the result of a failure of supervision or a want of care. Now, this is precisely the place, as well as in the schedule, where one would expect the local authority to be saying, we invite the court to find that the parents or one of them inflicted the injuries that we say the child suffered. But here they leave open in the widest possible way. And it's true to say, obviously, at paragraph 17, that the local authorities say they don't accept the jump onto the bouncer in 2020 as an explanation. But nowhere did the local authority go on to explore with the parents in evidence in 2022 what might else have happened in 2020. There is no exploration of that at all. So when at our paragraph 10 we say very little cross-examination directed at the causation of the skull fractures undertaken, we've struggled to find anything of any relevance. But if we're still in the supplementary bundle, the local authority's cross-examination of the father starts at A826. I'm sorry to say that the transcript of his evidence has not yet reached the parties and therefore not the court, so we're reliant on the note taken by Malona Jr.'s then pupil. So at 826 we see about just below line 103, we see Mr. O'Brien's cross-examination of the father starting at 11:54, and the cross-examination starts with the July 2021 incident about the Peppa Pig bed, where the cabinet may or may not have wedged the child. We then get the bottom of A27 to move on to the child being visible to the GP about his diet and the stomach problems, constipation, etc. We move on to the top of A830, where there's some cross-examination from line 193 about cannabis. On the following page, the cross-examination moves at line 229 to the difference in parenting styles between mother and father and the installation of boundaries. Over the page at line 249, we get to the August 2021 incident. Still nothing said about the skull fracture in 2020. Over the page at 834, we get to the material on the phone or not on the phone, as the case may be. And then eventually, the last three questions of the cross-examination at the bottom of 834, line 313, we get to a question, well, we get to a statement, and in relation to the injuries in 2020 to Brooklyn, you say you know nothing about it. If there was an incident that he landed...
Don't identify the child by reading his name.
I'm sorry, my lord. If there was an incident that he landed on the chair, did you not see or hear it? When he was looked after by you earlier that day, nothing happened. No.
I think the next
you did
question is likely to be either, isn't it? You did something, is that...
exactly, my lord. Yeah. That's how I was going to read it.
Either you did
something then, or you know something happened and then. No. And that is the extent of the local authorities' cross-examination.
It's not a series of unfortunate accidents.
No.
Is the next closing question.
Exactly.
Well,
it's a statement to which there's no answer.
Yeah.
That is the extent of the way in which
so
it was put.
What other cross-examination would have been appropriate?
Well, my lord, typically...
Beyond what had taken place back in 2001?
Well, typically one might revisit the circumstances in which the local authority suggests that the injury came about in February 2020. So if it's the local authority's case that the tensions between the parents in 2021 existed in 2020, and the local authority might have put to the father precisely that 18 months earlier, exactly the same behaviour that was being exhibited in the summer of 2021, exactly the tension between his wishing to instil boundaries with the child against mother's more relaxed style, that also existed 18 months earlier. If there was other latterly found contemporaneous evidence about the nature of the parents' relationship at the beginning of 2020, that might have been put.
But I thought your submission, which seemed to me to be good, was that there wasn't any more information. In other words, it wasn't that, take an analogy, someone was constructing a building and there was more in the construction
Yes.
progressed during that time. It was simply that another light was being shone on the building.
Yes.
By the subsequent findings. So that is what lies behind my question to you as to what further cross-examination would have been appropriate in circumstances where the facts hadn't changed.
Well, the local authority's position was that the facts had changed, that the nature of the parents' relationship, as discovered to be the case, according to the local authority in the summer of 2021, was the same as the nature of their relationship in 2020. That wasn't put. That wasn't explored. Now, it may have been that the parents' answer was, well, in 2020, we had a newborn son, we were very happy, we didn't have the stress of proceedings, etc., etc. By the time we got to the summer of 2021, we'd been involved with the stress of proceedings over the previous 14 months. We hadn't had the opportunity to bond with our baby. He was exhibiting difficulties with his constitution, all sorts of problems that might have meant that their relationship and their ability to parent in August 2021 and July 2021 was different to that in February 2020.
But if you go back to what he said in the first judgment in 2021, he seems, I think, to accept that the baby bouncer scenario was not the probable cause of the injury. So that's a finding on probability.
Yes.
Possible, but not probable. So how does the probability of that not being the cause get displaced? It gets displaced because he finds, amongst other things, that the father would have been out of character for the father to hit him on that, to hit the child on the head, or do something else. The probability of the baby bouncer scenario, i.e., it's not probable, though it's possible, hadn't changed at the time of the second hearing. But it might be said that in the light of the judge's finding about what the father did in 2021, his reason for ruling out the most probable cause of the 2020 injury had been undermined.
Well, my lord, that is the way in which the local authority, supported by the Guardian, put its case.
Yeah.
The response to that in our submission is that the father's character may well have changed on an isolated moment in response to particular circumstances on one night in July of 2021. But the local authority had not established to the satisfaction of the judge that his character had changed both throughout his care of the children in 2021 or back in February 2020.
Yeah.
Nor had it been put to him in terms that his character in February 2020 was identical to his character at the moment that he is now being found to have caused the injury in July of 2021.
Yeah.
And so it's no wonder we say, and I come back to what we submitted earlier, it's no wonder that the judge identifies the essence of the local authority's case as being simply because you find, Judge, or we invite you to find, non-accidental causation of injuries in 2021, are you then required to come to a different view about the February 2020? Because they didn't establish the groundwork. They didn't put the groundwork in place that would enable the judge to say, despite the fact that there was this was an injury caused in February 2020 using a different mechanism at a different time in different circumstances, nevertheless, my finding about July 2021 directly impacts and must lead to a different finding about the incident in February 2020. And that lies behind the whole thrust, we say, of the judge's reasoning in his judgment. Might we add, if it's not to over-egg the pudding, that the guardian, the cross-examination on behalf of the guardian of the father is equally thin in its exploration of the family circumstances in February 2020 that might have led to an injury. I won't take my lords and my lady through the cross-examination that goes in a similar way, dealing with many of the other incidents, and eventually we come to the bottom of page 843 in the supplementary bundle, A843, line 535. Here there's an attempt to draw a link between the incident in August 2021 and the February 2020 incident, and whether or not the child was seen to be distressed in 2020 in the same way or a different way to August 2021. And the father simply says, I don't remember. And then over the page, line 549, that's simply a question suggesting, but it's repeating the balance of the expert evidence about the February 2020 fracture, and saying, well, in the light of that expert evidence, do you think mother might have done something? No, says father. No direct accusation against him or his circumstances. And then we get to 555, which seems to be an exploration about the circumstances in 2021 as to whether or not there were circumstances. Child was crying, maybe he was smoking weed, etc.
I don't understand this question, because it seems to suggest that the child was out and the father was crying. It must be the other way around, mustn't it? Child was out and the father was crying.
Yes, it must be the other way around. Yes, it must be the other way around. That's certainly the way I've read it, my lord. But the nature of the point is the same. This is a reference to how the injuries in the summer of 2021 might have been caused by the father, not a reference to how he might have caused the fracture in 2020. Nothing is put in that regard. And then over the page we get to Milena Jr.'s re-examination of the father. So again, the judge finds nothing in the threshold to indicate what either the local authority is saying about who or how the skull fracture was inflicted, nothing in the opening note, nothing in the cross-examination of the parents.
weren't all the papers from the 2020 proceedings available in the 2021 proceedings?
They were, my lady, yes.
So were allegations like that made in the 2021 proceedings?
But not in the... They were,
Right.
but not in the context of the circumstances that subsequently were said to have prevailed in 2021. That is why we say, if the local authority's case was put at first instance in the second trial on the basis that the injuries that were found in the summer of 2021, at least one of which the judge has found to have been inflicted, must lead the judge to come to the conclusion that the February 2020 injury was inflicted. Then they need to provide some greater causal link between those two factors than simply the child was injured 18 months later and therefore must have been subject to an inflicted
it's not
injury.
quite that, is it? It's saying a one-off injury in 2020 might be accidental, but when you find the same child being injured a dozen times in the following month, 2 months, then it really looks as though the first one is not accidental. Now, I'm not saying those are the facts, but subsequent facts, as my lord put it, cast light on the original fact.
And isn't
That
it
once is accidental and a whole series of times makes it less and less likely that it is.
And isn't it inherent in the decision to reopen that the judge is being asked to revisit his conclusions about the causation of the 2020 allegation, and that must implicitly involve him being required to revisit whether or not the 2020 injury was caused deliberately?
My lady, absolutely.
Right.
And therefore one would expect in our submission the circumstances in 2020 to be revisited in the course of the cross-examination of the parents to suggest to them and to seek their answer as to how the injury came to be caused, now that we know the state of the family and the household in the summer of 2021.
All right, well, I think we've got them.
None of that was...
Yeah, no, we've got that point.
And if one goes, if we may, in the supplemental bundle at A890 to paragraph 95 of the local authority's closing submissions.
Yeah.
I think that's about the most explicit
It is, my lord.
written statement.
Yes.
Yes.
But it reflects, we say, what the judge said in paragraph 91 of the judgment about the way in which the local authority put its case. So that the local authority criticised on appeal the way in which the judge characterised their case in paragraph 91. And yet, when one looks at the most explicit identification of the way in which they put their case, at paragraph 95 of the closing, that's precisely the way in which they put it.
Yeah.
And the judge was entitled to say, we suggest, that that's simply not enough. It's not enough just for the local authority to say, well, because of what happened in 2020, because of what happened in the summer of 2021, February 2020 must have been non-accidental. And the criticism of the judge's characterisation of the local authority's case, we say, simply doesn't hold water on that basis. Well, my lords, I come to the end of our submissions on that part of the
Right, how much longer do you think you will be, Mr. Derrick?
My lords, maybe another half an hour or so.
Right, well, in that case, we'll break now, resume at 2.
All right.